5, 4, 3, 2, 1, start.
This is a suit for recovery of rupees 43 lakhs 80,000 full stop. It is alleged in the plaint that Messrs. JP Enterprises, which was a partnership firm, was dissolved by dissolution deed dated 12 April 1996, and thereafter the plaintiff Ramesh Kumar has been running this firm as his proprietorship concern full stop. The defendant Surender is running business under the name and style of Messrs. Raghunath Enterprises full stop. It is alleged in the plaint that under an oral agreement between the parties, the defendant was appointed as a stockist of the state lotteries including daily lotteries etc. on wholesale rate basis full stop. Stanza. As per the terms and conditions of the argument, the plaintiff was required to dispatch lottery tickets to the defendant from Delhi as per the requirement of the defendant full stop. The defendant was required to make payment to the plaintiff within a week from the date of the draw full stop. In default of payment, the plaintiff was entitled to interest at the rate of 20% per annum for the period beyond 15 days from the date of draw full stop. It is alleged that the defendant is liable to pay a sum of rupees 30,000 to the plaintiff towards price of the lottery tickets after adjustment of part payment of rupees 1 lakh made by him on 6th June 1995 full stop. The plaintiff has also claimed interest on that payment at the rate of rupees 20% per annum, which comes to rupees 30 lakh, thereby making a total sum of rupees 43 lakh full stop. The defendant has contested the suit full stop. Stanza. He has taken preliminary objections that this court has no territorial jurisdiction to try the suit and the suit is barred by limitation full stop. It is further alleged that since the agreement was executed between the defendant and Messrs. JP Enterprises, the plaintiff has no cause of action and no right to sue the defendant full stop. On merits, it is alleged that the defendant was in the business of sale of lottery tickets till the year 1992 and had purchased some consignments of lotteries from Messrs. JP Enterprises, payment of which were promptly settled and nothing is due from him full stop. The defendant has also denied the alleged oral agreement between him and Messrs. JP Enterprises as also the agreement to pay interest full stop. As regards the payment of rupees 1 lakh, it is alleged that this amount was paid to the plaintiff on 6 June 1995 as a loan full stop. Stanza. On this issue, the plaintiff, Mr. Ramesh Kumar, in his affidavit by way of evidence, stated that Messrs. JP Enterprises, which was a partnership firm till 1st April 1996, was dissolved by dissolution deed dated 1st April 1996 and now he is its proprietor full stop. During his cross-examination, he stated that after dissolution of the partnership firm, he took over all its assets and liabilities being its proprietor full stop. Though the original dissolution deed was not produced by the plaintiff and consequently its copy filed by him could not be exhibited and was marked as Mark A during his examination before the learned joint registrar, even if the document Mark B is excluded from consideration, the unrebutted deposition of plaintiff is sufficient to prove that Messrs. JP Enterprises was dissolved with effect from 1st April 1996 and all its assets and liabilities were taken over by the plaintiff as its proprietor full stop. Another important factor to be noted in this behalf is that no other partner of Messrs. JP Enterprises has sued the defendant for recovery of the dues of the firm, which in turn supports the oral deposition of the plaintiff that he had taken over the assets and liabilities of the erstwhile partnership firm with effect from 1st April 1996 full stop stanza. The issue is decided against the defendant and in favor of the plaintiff full stop. It is an admitted case that the defendant made payment of rupees 1 lakh to the plaintiff by way of demand draft on 6th June 1995 full stop. Though the case of the plaintiff is that in fact the payment was received by him on 10th June 1996, that would make no difference since the High Court was closed in June 1998 and the suit was filed during vacation on 23rd June 1998 full stop. Section 19 of the Limitation Act, to the extent it is relevant, provides that where payment on account of a debt or of interest is made before the expiration of the prescribed period by the person liable to pay the debt, a fresh period of limitation shall be computed from the date when the payment was made. Full stop stanza. In case part payment by way of a demand draft was made by the defendant to the plaintiff on 6 June 1995, this being a payment in writing, a fresh period of limitation concerned from that date, and since the High Court was closed in the month of June 1998, the suit having been filed during the same vacation on 23rd June 1998 would be within the prescribed period of limitation. Full stop. The dispute between the parties, however, is as to whether the amount of rupees 1 lakh was paid as part payment towards the dues outstanding against the defendant on the date of payment as claimed by the plaintiff, or it was paid as a friendly loan by the defendant to the plaintiff as alleged by the defendant. Full stop. In his affidavit, by way of evidence, the plaintiff Ramesh Kumar has stated that part payment on account was made by the defendant on 6 June 1995, while letter exhibit P2 and receipt issued by the plaintiff in this regard on 10th June 1995 is exhibit P3 full stop stanza. PW2 Shri Ranjit Singh, who is working with the plaintiff, has corroborated the deposition of the plaintiff in this regard and has stated that last payment was received from the defendant via memo number 184 dated 6 June 1995 for rupees 1 lakh wide demand draft, which was duly realized by the plaintiff. Full stop. The original memo dated 6 June 1995 is exhibit PW2 over A. Full stop. I see no reason to disbelieve the oral testimony of plaintiff and his employee Sri Ranjit Singh as regards the nature of the payment made by the defendant on 6 June 1995. Full stop. During his cross-examination of PW2 Shri Ranjit Singh, also no suggestion was given to him that the document exhibit PW1 over 1 was not issued by the defendant. Full stop. When a witness deposes a particular fact and no suggestion to the contrary is given during his cross-examination, the party against whom the deposition is made deemed to have admitted that part of the deposition which thereby remains unchallenged. Full stop. Stanza. Therefore, by not suggesting to PW2 Shri Ranjit Singh that the document exhibit PW1 over 1 was not issued by him, the defendant is deemed to have admitted the issue of this document by him. Full stop. Even otherwise, exhibit PW1 over 1, on which the name as well as address and telephone number of Raghunath Enterprises, of which the defendant admittedly
is the proprietor is correctly printed does not appear to be a forged document full stop. The memo exhibit PW2/1 shows that the payment of rupees 1 lakh was made in account, which implies part payment full stop. The receipt exhibit P3, which is a computer generated receipt as stated by PW2 Shri Ranjit Singh, also shows that the payment of rupees 1 lakh by demand draft number 7776 dated 25th May 1995 was received in the account of the defendant maintained with Messrs. JP Enterprises full stop.